Good afternoon, ladies and gentlemen. Ready to start the meeting for the Wareham BoS Selectmen Sewer Commission. If I can remember what date it is, Wednesday the 17th at 3:30. I'm going to read a little thing before we start. I am requesting all cell phones and electronic devices be turned off in a mute position as not to disturb the meeting. Any member of the public also has a right to make an audio or video recording of an open session of a public meeting. A member of the public who wishes to record a meeting must first notify the chair and must comply with reasonable requirements regarding audio or video equipment established by the chair so as not to disturb or to interfere with the meeting. The chair is required to inform other attendees of such recording at the beginning of the meeting. We will have a news reporter recording today. She's sitting to my left. And we'll have a clerk. Ellen, thank you very much. That's what we like as volunteers. Roll call.
Mr. Chair, there are two selectmen present, Mr. Cruz, Mrs. Begley, and the Town Administrator, Mark Andrews, is present as well.
Thank you very much. This meeting is a special call meeting. Is for 2 Beach Street extension. So we can have the main players come forward, please. And make sure your mic light is on, and we'll go from there.
Thank you, Mr. Chairman, members of the Board of Selectmen. My name is John Whitten. I'm an attorney in the town of Duxbury, Massachusetts.
And thank you, Mr. Chairman. Craig Medeiros, attorney for the petitioner, Michael Acaba.
Okay, thank you very much. Mr. Whitten, on 2 Beach Street extension.
Yes, thank you, Mr. Chairman, members of the board, Mr. Andrews. I was contacted by Mr. Andrews about 4 months ago regarding a matter at 2 Beach Street extension. And the issue, Mr. Chairman, can be summarized, I think, as follows. There is a recorded affordable housing restriction that runs against the property at 2 Beach Street extension. It's an affordable housing restriction of the same form and format that we see in the Commonwealth that is underscored by the statute, Chapter 184, Section 31 through 33. And it provides the municipality, in this case, with certain rights of protection against affordability for future sales. So it's a restriction on affordability that essentially runs with the land in perpetuity or for the longest period allowed by law. The restriction is recorded at the Registry of Deeds. There's no dispute that the restriction has been recorded for many years. And I was approached by Mr. Andrews with a request for an opinion as to whether or not the restriction is still valid and or enforceable by the town of Wareham. Through correspondence with Mr. Andrews, members of the Board of Selectmen, Mr. Medeiros, who's representing the seller, and your town council, Rich Bowen, there are several memorandum from me and emails from me to all parties concerned. And my opinion has been and remains to this day that the restriction that's been recorded at the Registry of Deeds cannot be released by an action of the Board of Selectmen. And the reason why is the restriction is a real property interest or an interest in real property. It runs with the land. It cannot be released by an action by the Board of Selectmen. It can only be released pursuant to statute by an action of town meeting, annual or special, or, of course, and I think if the selectmen were to seek release of this, the more preferable route would be through a court order. A motion for a declaratory judgment with the land court or the superior court seeking to nullify, abrogating, rescinding, removing this restriction from the books would be the only other method, in my opinion, of removing this restriction. I understand fully why the seller wants the restriction released. I've never interfered with what their motives might be. I've simply opined and continue to opine as a matter of law what your powers and Mr. Andrews' powers are under the statute. And I've been consistent, despite, I think, attempts not from my brother, but from others, to pressure or escalate the matter that the restriction should be released. I don't believe that you can. I'm very confident in that. Your town council is very confident in supporting my opinion. And I think we're here today to see whether there are some alternatives that are available to both the town of Wareham and Mr. Medeiros' clients. The last thing I'll say, Mr. Chairman, subject to any questions that you have, is I've proposed offered two solutions to the release. One is town meeting, and of course there's a time issue there. Town meeting occurs whenever the selectmen choose to call a town meeting, so at this point it would have to be a special town meeting, where the voters would be authorized to release whatever real property interest the town has in this property, or through a court order, an application by the seller or landowner to the Superior Court or Land Court, asking the court to order that the restriction is null and void. The town's position on that declaratory judgment could be to assent to it. The Board of Selectmen could agree that, in principle, you don't feel you have any enforceable rights here, and assent to the motion that Mr. Medeiros would bring, and that would expedite the process, and the court would rarely, in my experience, interfere with an assented to motion. So those are your two options, meaning the Board of Selectmen, Mr. Andrews' options. I see no others. It would be irresponsible of me, and I think it would violate my duty to you to suggest any other option, because I do not believe you can sign with any authority a release of the restriction. You simply don't have that authority as a Board of Selectmen.
Thank you very much.
Right.
Mr. Medeiros?
Thank you, Chairman. Like Attorney Wynn just opined, I do agree with his opinion for the most part. And one option which we just discussed prior to this meeting was potentially having the Board of Selectmen assent to or agree to a declaratory judgment, which would kind of satisfy Attorney Whitten's procedural concerns that the Board of Selectmen do not have authority to grant this release or acknowledgement that there was no valid restriction, while at the same time satisfying my client's concerns as to the timing of the release of this restriction. So that's really something that I'd like the board to consider, and would make my client a lot more comfortable, is if you would assent to such a judgment. I think that would be mutually beneficial moving forward, and we can get this resolved in a relatively quick time frame. In terms of that judgment, we might also want to include an additional property owned by Habitat for Humanity, which is also impacted by one of these restrictions, which didn't meet the original requirements, which are imposed under Mass General Laws, Chapter 184, Section 31.
You want to state your name and...
Good afternoon, Mr. Chairman. Mark Bobrowski, Town Council's Office.
Right, we have the mic right handy.
Yeah, just use the mic.
Good afternoon, Mr. Chairman. Mark Bobrowski from Town Council's Office, Blackman, Bobrowski, and me. I apologize, I was working with Mr. Charbonneau over there on a planning board problem, which we happily have made some progress on. So shall I just go into delivering my report?
Yes, you can.
All right, you've asked me to look into the documents and to make a determination as to the proper procedures here for this, I'll call it the alleged affordable housing restriction. I think all parties are in agreement, based upon what I can see in the file, that the procedures that attended the formation of this back in 06 or 07 were flawed. There was no vote by the Board of Selectmen to accept it. There was nothing at DHCD that was necessary under the Chapter 184, Section 32. Nor was there the submittal formally of the LIP unit-only application, which is all supposed to be done in order for this to be an effective affordable housing restriction. I noted in the file that DHCD concurred with that because they were quite willing to release it. You have an effective release from 3 weeks ago from DHCD, and I noted that the Buzzards Bay Habitat for Humanity chapter also has entered a release here too. So what I find myself refereeing here, if you will, is one lawyer who says that form is to be exalted over substance, and another lawyer who's saying that substance is to be exalted over form. And I find myself coming down on this side of the equation for the following reasons. First of all, there's no doubt that there is a recorded affordable housing restriction currently on file at the Registry of Deeds. It's just inescapable. I have the document in front of me. Now, it wasn't done properly, but it's still on record. And so it is an encumbrance on the property. I agree with Mr. Medeiros that there is no legal effect to the document if it were pushed. If you took it to a judge and you said, Judge, look what happened here back a few years ago when this was all done. It was done completely improperly. DHCD agrees with it. The Habitat agrees with it. I have no doubt that a judge would rule it's a non-factor. The document is of no legal consequence, but it's still on record. The statute says that the only way that there can be a release of an affordable housing restriction is in the same manner that you would create an affordable housing restriction, and it benefits the town of Wareham. So there has to be a public hearing by the Board of Selectmen in order to release it before town meeting takes that action. It doesn't say in the statute, oh, but if it's a defective document because you didn't follow the procedures, you can just sign an acknowledgement and certification and it all goes away. The statute it doesn't say that. It doesn't make any exceptions. I could see if you took Mr. Medeiros' position to the extreme that every affordable housing restriction could be reduced to or could be eliminated from the books by acknowledgement and certification if only you could find some process that was allegedly flawed in its adoption. But I don't think that's what the legislature had in mind. So, like it or not, and I don't think it's a very happy result, the only technical and legal way to get rid of the affordable housing restriction would be to follow the procedures as set forth in the statute. And in that regard, I think Mr. Whitten is exactly right. The town cannot make it go away simply by signing a piece of paper and recording it at the Registry of Deeds. Now, from the town's perspective, I mean, it's neither here nor there in that no one is seeking to enforce this. Clearly, the town is not trying to obtain any rights under it. From a conveyancing perspective, if I were the bank looking at this with a buyer coming in, I don't think that's the case we have right now. I think it was bought at auction, so it's already in the hands of somebody. But the next time this goes to flip in a subsequent transaction, it's readily findable. There's the affordable housing restriction, book and page, under the grantor-grantee index at the Registry of Deeds. Okay, it's technically flawed and won't apply to you. Well, where's the release that was formally done in accordance with statute? That would be the conveyancing lawyer's perspective, I think, down the road. They would want to see the paper from DHCD, check, the paperwork from Buzzards Bay Habitat, check, and the vote at town meeting following a public hearing by the Board of Selectmen, no check. So it's going to create a cloud on title if the town doesn't do this the proper way. In the alternative, I think Mr. Whitten is right. You probably can go to see a judge and have the judge declare it null and void and remove it per order, recordable order at the Registry of Deeds. So that's the way I come down on this. I think we're all in agreement that it's of no legal effect because it was flawed in its inception. But as to the end of it and the riddance of it, I think Mr. Whitten has called it correctly, and it needs to come off through the adoption of the formal procedures in Chapter 184.
Thank you very much.
Okay.
Now that we heard it, Mr. Medeiros?
No, I mean, I agree. Like I said, I agree for the most part with the opinion. The reason why I'm appearing before you is I want to obtain comfort that the Board of Selectmen is going to support releasing this document. And that's really our concern in moving forward in the fastest manner as possible to release it, whether it be either A, a town meeting vote, or B, a declaratory judgment. I mean, I don't know if we're probably too late at this point for a town meeting vote. It's probably borderline. I know you have a town meeting vote coming up where warrants are being accepted. I believe it's my understanding from the last meeting that all warrants need to be produced by next meeting. Okay.
September 2nd is the last day for warrants, is that correct?
Petition article.
Petition articles, so September 2nd, so that would be true.
That's correct.
Okay.
So you have until September 2nd.
So there would be time to place this on the agenda for the next town meeting?
To place it on the warrant, yes.
Okay.
So the best thing is, like you just discussed, is what's best advantageous to you and your client. I know you want to do it the quickest possible way. So if you can try to do both avenues, it might work out. You know, if you try to go through the court and that, because the court may be quicker than our town meeting. Our town meeting is in October.
Correct. And I mean, the second concern about the town meeting is just because the warrant is placed on the town meeting vote is not a guarantee that it will be passed through the town meeting vote, which is my client's concern is we only go the town meeting vote avenue. Let's say that does not pass, then we still have to go through the declaratory judgment avenue simultaneously. I mean, the issue with the declaratory judgment avenue of releasing this restriction is if it was basically a controversial, or if you fought to keep this affordable housing restriction, it would be a long, drawn-out process. if the selectmen assented to the release of the restriction, it'd be a relatively quick process. So again, I mean, judging your comfort level with releasing it is another concern of my clients, which I wanted to gauge as part of this meeting.
So as of right now, going by our clients and what they have given, our lawyers, by what they have given us, we're in favor of heading in that direction. So you know the direction that we're headed, and it'll be up to you and your client to find out which way is the best way that's going to suit you to get this done as efficient as you can. If you're in understanding with that, then we can consider this matter closed, and then you can proceed in whatever avenues that you have to go to resolve this. So we just want to make sure that everything is done equitable.
Correct.
And if you're satisfied and we're satisfied, I think we can proceed on the right course.
Correct. That sounds very fair. And again, I thank you for calling the special meeting. Both of the attorneys have been very responsive going forward. I know it's been a long, drawn-out process, but in the last couple of weeks, we really were able to pull it together. So again, I appreciate the board's help in kind of pulling this together and getting this meeting.
Well, I appreciate you
together.
working with our attorneys and making all this come to fact. And Mr. Andrews, do you have anything?
Mr. Chairman, if I could, just for the record, because I think it's important, would it be fair to say, Attorney Medeiros, that the affordable housing restriction was on the deed prior to the purchase by the Habitat? That goes back some years, because I have I have an affidavit in front of me that indicates that that is the case, that they probably should have known that there was some form of restriction on it, whether it was flawed or whatever, because I just want to go back to
My client should have known that?
well,
Or-
well, I'm just saying to you that I think the process, if you can go back several years, because I have advertisements in the Wareham Courier from October 7th, October 14th, and October 10th of 2010 that show the restriction that's listed in the newspaper that would have said, probably back then, you should start this process up. You would have made the Springtown meeting, is my point.
What the issue was is I actually wasn't involved in the initial portion of this transaction. What happened is it was represented to my client at the foreclosure sale that this affordable housing restriction was invalid, and that's why he never did anything to
Okay.
release or get rid of it, is because it was represented to him by the attorney for Habitat at the time that this restriction was invalid. So he was always under the assumption it was invalid. It wasn't until he had a third-party purchaser to purchase the property that it actually came to fruition that he realized that it was on record.
Okay.
It may be invalid. It wasn't set up properly, which is I believe what Attorney Borowski and Attorney Wynn are stating, but it's still a title issue. So, like I said, my client got some bad advice at the time, was led to believe something which he shouldn't have believed. But,
Sure.
if he had done his due diligence correctly, he might have found this out. But that's not what was represented to him.
So I just wanted to make sure the record was clear.
And I guess, Mr. Chairman, my key point is that if you don't take the statutory steps to release it, it will remain a title issue. The only way to get rid of that possible cloud on title is for you to perform under the statute, assuming that's the wish of the selectmen and the town meeting.
Okay, so you're advising us to, well, we can talk to you later on. You can
Sure.
talk to Mr. Andrews, and you can talk to your client. We're all in agreement, and I'm glad that we did work together as a team, even though we're on both sides of the fence. But we are here to help you and your client. So nothing else said. If anybody doesn't have any, Mrs. Baker?
I have a question. I kind of looked at some of that paperwork as well for your client, Attorney Medeiros, and it was stated in the newspaper article when it came up to auction that it had affordable
Correct.
restriction. At
Publication.
60%. Right.
The publication said it is subject to an affordable housing restriction.
So I'm hoping that anyone that wished to bid on that property certainly had that information as well, that it was considered an invalid restriction.
Correct. It was in the publication that it was subject to the affordable housing restriction, which in the chain of title, it was subject to the affordable housing restriction. However, at the foreclosure auction, it was purported that the affordable housing restriction was invalid.
At the auction, it
at
was
the-
reported as invalid.
Correct. It existed as of record, but it was invalid because the proper statutory steps had not been undertaken, which I believe everybody's in agreement with. But the proper steps to actually release it haven't been followed to this point in time, and that's what we're trying to do at this point. But I think everybody's probably in agreement that it is invalid. That probably was a proper statement. I believe my client took invalid to be, you don't need to necessarily go through the statutory process to release it. He took invalid to be, don't worry about it.
Oh, unfortunate.
Correct.
Well, I'd also just add, though, I think invalid is in the eye of the beholder. This is our opinion, and I think Mark shares it. This is an interest and a benefit to the town of Wareham until you seek to release it. And that's been the rub. Now, the release is through town meeting or judicial decree. But until that happens, there is an interest, however one measures it, strong, weak, intangible, but there's an interest that runs to the town. And until the legislative body, town meeting, or the court gets rid of it, it's yours. And that's been our position all along, that the Board of Selectmen, for good or for bad, don't have the authority to relinquish that interest.
In fact, that's my point, is that even if you sign the paper that Mr. Medeiros has proposed, the next time the property goes through a bank transaction,
The same thing.
the lawyer's going to say, what's this? This isn't the way you release an affordable housing restriction pursuant to statute. And it will raise the same flag that exists today. So it's best to just clean it up. I do want to point out that, you know, there are two documents in the file that I was provided with, one from Kate Racer at DHCD, dated August 2nd of this month, releasing DHCD's interest. This is a remarkable document. They're in the business of affordable housing, so obviously they agree that it's invalid, and that's the position that they've taken. So
I just have a couple more questions, sorry.
Yes, Mr. Baker.
After the foreclosure, was there another sale of the property?
No.
So it was purchased at foreclosure
My client then
by your client?
then proceeded to rehabilitate the property.
Mhm.
Did a number of, he basically rehabbed and raised the whole inside of the property, put it on the market, and then a buyer liked the property, put in an offer, the offer was accepted, and then this issue was raised during the title examination of the property.
So there wasn't more than one sale of the property once it was foreclosed?
Correct. My
Okay, so
client
there was-
bought it at the foreclosure, still owns it, is now trying to sell it to a third party.
And now the third party, from what I understand, is residing in that home?
No, they're not.
They're not?
We've actually discussed an option where they might be able to reside in the home until this title issue is resolved. They may pay rent until such time as that happens, but at this point they are not residing in the house, is my understanding.
Okay. Just wanted to clarify because, you know, you hear all kinds of things. So.
Correct. That's actually an option. We've discussed that until the title issue is resolved. They may reside there, pay rent until it's resolved, and then at that point they could purchase the property. But at this point, I do not believe anybody is residing at the property.
Thank you.
Yeah, I see you standing, Slavy, but this is not, Mrs. Slavin, but this is not a public hearing. You want to step forward?
Thank you. I know this is not a public hearing, but as the chair of the Affordable Housing Trust, it is my understanding that any profit made on a foreclosure of this property, any profit made was to be turned over to the Affordable Housing Trust account. We have heard from the Habitat for Humanity that there was no profit, but I just wanted to clarify that if the court or the town meeting decrees the affordable housing restriction, turns it off, makes it invalid, whatever, that also precludes the Affordable Housing Trust from receiving any profit. I just want that clarified.
Well, we have lawyers on each side of you, so I think we can.
The Affordable Housing Trust is not named in the deed whatsoever.
I believe it is listed that any profit made on a foreclosure would go to the Affordable Housing Trust. That is my understanding
If
by
there's
reading
an
the
affordable
deed.
housing restriction on the house.
It doesn't say that, though.
Okay, instead of end all this debate, we have the two lawyers here. Why don't we get together?
Mr. Chairman, I can offer this, and
Yes, go ahead.
And I think Mark will as well. The restriction that normally provides the excess profit or capital gain, for lack of a better phrase, to the Affordable Housing Trust would apply here, but for the fact that the argument is going to be that the restriction's invalid. So if it were a valid restriction, in other words, if town meeting were to reject this proposal, the court rejects it and says, forget what DHCD did, this still applies to the town of Wareham, then you would be able to argue for the excess profit. If you go the other way, which is the direction that Mr. Medeiros is pushing for, which is it's invalid, there would be no cash on the table for the trust.
I agree with John's assessment. There are provisions in the document that do refer to the Affordable Housing Trust for the municipality, but I agree that because the restriction is flawed, it's not a restriction at all. It wasn't accompanied by the proper procedural steps, and therefore, I think it's a nullity in terms of its legal effect.
That's fine. I just wanted to make sure that
Clarification.
became part
Good.
of the record, and thank you
Yep,
very much
yep.
for recognizing it.
And thank you. So it's a good thing we have both lawyers here to clarify everything right in the beginning, so.
Good thing we're agreeing with each other.
I know. Hey, that's a good thing. Any other questions? If not, need a motion?
I move to adjourn.
Motion made. I even let the town administrator make a
There's
second.
only two of us, so we
Right.
couldn't make any motions. I really can't make a motion without a
And
quorum.
at 3:56, we're adjourned. Thank you very much.
Thank you again, Chairman and Board.
Right.
Yeah, it is. I just,
Wasn't it just for the municipalities?
no,